I put this separately. My opinion is that the majority of your closing should not be spent on the law. And this is one of those things where a lot of attorneys are going to disagree with me on. But again, my rationale here is we're making our decisions emotionally, not logically. The law is boring. It may be unintelligible to certain jurors, but we can all understand anger. We can understand recklessness. We can understand rage. So use the optimal amount. You know, what is the optimal amount of spicy? Right, from 0 to 100. Probably not 100, and it's definitely not 0. So what is the optimal amount of preparing for your ITAP presentations? Right, you could spend every single second between now and your trials on Saturday. That's probably too much. Or you could blow it off and do 0. So what is the optimal amount? And it's obviously more art than science. Keep it simple and to the point. Prosecutors here are going to want to stab me for this one. Don't argue uncontested facts. If no one's arguing about jurisdiction, no one's arguing about ID, if no one's arguing about the date, don't waste time on those topics. The jurors only have so much attention. And if you want to burn it on elements that no one's arguing about, be my guest, because that's your time, not mine. We use jury instructions. There will be parts of the jury instructions that are relevant to you. There's going to be parts that you want the jury to use. Identify those as succinctly as possible. You can use an Elmo, you can use a blow up, or you might even just repeat them. And of course, burdens of proof. Objections. These objections are pretty much only going to find in closing arguments. Burden shifting. If you're a defense, anytime the plaintiff or prosecution says the defense didn't, objection, burden shifting. Anytime that anything is suggested that the defense could have, would have, or should have done, objection, burden shifting. Misstating the law. You've got to know the law. You've got to know your jury instructions. If they get up and they're misquoting something from the jury instructions, you need to know that. You need to call that out. Misstating evidence. Witness so-and-so said blah, blah, blah. No, that's not quite what they said. Objection, misstating the evidence, may we approach. And the golden rule. Anyone know what the golden rule is? The golden rule is, imagine how you would feel if you were shot in the back by police. Imagine how you would feel if you were overworked running a liquor store and someone came in. It's just an easy little fix. Change you to someone or to the defendant. What do you do when you object in closing? You move for a mistrial, which you probably need to do. You're probably not going to get it, but for the record, and certainly when the stakes are higher, you're in a death penalty case, every objection needs to be followed by a motion for mistrial. The other thing you can do is ask for a limiting instruction. Objection, burden shifting. Your Honor, we request the court to give a limiting instruction on the burden of proof. Boom, and then the judge says, the court would remind the jury that the defendant is under no obligation to produce any evidence here. Man, you just got the judge to back you up, not even sustain your objection. He backed it up. He doubled down on it. Summary. Hooks. Become the foreperson. Be the reasonable person. Arm your allies. Pose questions. Don't you dare say my client. We, us, let's, how do we figure this out? Pretend you are a juror as much as you can. Rebuttal. You're responding on your terms at a designated place of your choosing. You are not letting the other side dictate how you're going to run your closing argument. The law, use the optimal amount